My lord, may I mention one of the case, my lord?
From the list. From the list. No mentioning from the list. Let the matters be called.
Yes, Lordship. Serial number 27, Lordship. From Delhi Cause List, MA 234/2016, Lordship. I am appearing behalf of the Mahua Palik, Lordship. She is not well, feeling well, Lordship. So, may I pray for not today, for after vacation, Lordship. Any date may be fixed, Lordship.
27 on the health ground, as mentioned, on the health ground of Ms. Mahua Palit, Learned Counsel of the appellant. This case is that you have taken consent of the other side.
Yeah, yes, Lordship.
With consent. What is your name?
Bandana Kumari Sinha, Lordship.
As paid for by Bandana Kumari Sinha on behalf of Mahua Palit. This is adjourned to list of application.
Obligement, Lordship.
Anyone from the list? Any mentioning from the list? Okay.
My lord.
Yes.
My lord, may I mention one of the case, my lord? MA number 8/1/2021, my lord. In this case, my lord, I file a IA number 7188. my lord, मैटर है कि उसमें हमको एक्स पार्टी ऑर्डर हुआ, एक्सक्यूशन में हम पर वारंट ऑफ अरेस्ट इशू हो गया है.
Yes. Call the list.
From Delhi Corporate, under the heading for order, serial number 1, MA number 434 of 40, Mr. Mahesh Prasad Sinha, Mr. Sanjay Kumar Dubey, for appellant.
Yes. Yes, who is appearing? Who is appearing? Who is appearing? Yes, Mr. Singh, you are appearing in this case. Mr. Ram Subhak Singh, you are appearing in this case.
My lord, I mention out of the case, my lord.
Out of case mentioned tomorrow. You see the notice.
Obligement.
You have not gone through the notice. Yes, who is appearing?
Clement हो तुम ऑनलाइन किया
No one appears after vacation. What is the limitation?
Serial number 2, MA number 66 of 50, Mr. Sanjeev Verma, Mr. Amar Kumar Sinha, for appellant, Mr. Anjali Kumar, Mr. Pankaj Kumar Chaudhary, for respondent.
May please your lordship. This is an appeal, lordship, under order 43 rule 1U of the Code of Civil Procedure against the order of remand by the lower appellate court, by which, my lord, the lower appellate court has set aside the judgment passed by the learned trial court and remanded back the case to the trial court for deciding the issue of title. On the last occasion, my lord, the matter was heard at length. Eviction suit, my lord, has been decreed in favor of the appellant under section 11(1)(d) of the BBC Act. Against that, my lord, appeal was filed, and my lord, the lower appellate court remanded back the matter to the trial court for deciding the issue of title. This is the case. Lordship may kindly see the plaint. Eviction suit has been filed, Lordship, under section 11(1)(d) of the Bihar building.
Who was appearing on behalf of the opposite side?
Lordship,
Who is appearing? Mr. Pankaj, switch on your microphone.
Lordship,
Yes.
yes, yes. Lordship, I am appearing, but the senior is engaged, Lordship. So maybe heard in any physical mode, Lordship. Physical
Tomorrow,
mobilized, Lordship.
Mr. Sinha.
Lordship.
Tomorrow. Because as far as I remember, Mr. Sinha and you had argued that this is an eviction suit. The court says that there is no relationship of landlord-tenant, but you decide the type.
Lordship.
This was the
Lordship,
most probably.
yes, Lordship, trial court has come to the conclusion that no relationship between the parties.
When the what relief a party will claim is dependent upon the plaintiff. Now, if the
Lordship.
plaintiff has filed in his own wisdom a suit for eviction, then the court says that there is no relationship of landlord and tenant, finished.
Finish. Simple.
It is for the plaintiff to face the consequence.
Lordship.
Yeah.
So if the court says that no, I will decide title.
Lordship.
If the party does not want the title to be decided, who is the court to say that forcefully I will decide the title?
Yes, yes, Lord.
Tomorrow.
Oblige, Lordship.
Obliged, Lord.
Video number 3, MA number 289 of 15, Mr. D.C. Jha. For appellant, Mr. Amresh Kumar, Mr. T.M. Mishra. For respondent,
Lordship, order dated 14/10 to
Claimant.
I am on behalf of claimant, my lord.
14/10/2015 may kindly be seen, Your Lordship. Order dated 14/10/2015.
14/10/2015.
Yes, Lordship.
Yes.
Lord, letter producer, IA number 5458/2015. This interlocutory application has been filed under section Civil Procedure Code. It is submitted that appellant is ready to deposit major part of the awarded amount, and in that condition, the proceeding of the execution case number such and such pending in the court of District Judge Jamshedpur may be stayed. Considering the facts and circumstances, the appellant insurance company is directed to deposit 20 lakhs by way of check drawn in favor of the claimants before the tribunal, and the said sum of rupees 20 lakhs shall be handed over to the claimants with a direction that 5 lakhs each shall be deposited in the name of each of the claimants with the joint name of natural guardian. If the claimant is minor for 10 years as indicated by the tribunal, rest sum rupees 5 lakhs shall be withdrawn by the claimant number 1 on her behalf and on behalf of her minor children, and she shall be at liberty to utilize some rupees 5 lakhs as per her choice and will on deposit of check for 20 lakhs as indicated above. The proceeding of Miss Case number 9 shall remain stayed. Copy of the fixed deposit receipt must be furnished before the tribunal within 15 days from the date of withdrawal of the amount.
Yes.
Lordship, thereafter, this case has come on 8/7/2020.
Yes.
It has been reproduced. Now the condition is that I have to deposit 20 lakhs. Out of 20 lakhs, three fixed deposits, 5 lakhs each, and the 5 lakhs should be withdrawn by the claimant mother. Yeah, claimant wife, Your Lordship.
Yes.
And the fixed deposit has to be filed. It is because the 20 lakhs rupees has to be handed over to the claimants, and thereafter this Lordship, as per my instruction, we have deposited.
When?
My lord,
Within time frame.
yeah, they have deposited, my lord. My client has received. Yeah, my lord, my client has received it.
Have you deposited in the fixed deposit?
That receipt is required to be filed by them, Your Lordship.
Have you filed this?
My lord, as per direction dated 8/7/2020, in last but one before paragraph, my lord, it has clearly been directed to the appellant to comply the order that
Have you filed the affidavit?
No.
I have not filed, my lord. It was directed to the appellant and also to me. Because of illness, I could not file, but this week I will file, my lord. They have informed me.
Mr. Learned
Yeah.
Advocate appearing for the claimant submits that within a week he will file an affidavit, shown by the claimants, intimating this court that they have complied their part of the order dated 14/10/2015. This case after summer vacation.
Along with receipt of the fixed deposits, Your Lordship.
My lord, फिक्स डिपॉजिट का रिसिप्ट तो इनके पास होगा, my lord.
मेरे पास कहाँ से होगा? आपको देने का डायरेक्शन हुआ है, आप लेकर के फिक्स डिपॉजिट।
मेरे पास फोटो कॉपी है, वो लगा देंगे फोटो कॉपी।
Don't argue amongst yourself.
My lord,
That order, you comply the order.
my lord.
Don't argue amongst yourself.
Serial number 185 of 60, Mr. Alokral for appellant, Mr.
But in this case, the earlier the notices were issued upon response number 6, and Mr. Ashutosh Anand had some personal difficulty in appearing in this case. So he was excused himself from this appeal.
Your Lordship, in this case, I am appearing on behalf of respondent number 6, Your Lordship.
Lordship, I am for the 1 to 5, Lordship, claimant number.
Yes, what is this case?
6 seems to be the owner.
Your Lordship, in this case, I have filed an IA for addition of co-owners and also state of Jharkhand as opposite party, Your Lordship.
Why?
The copy is not with me. You may.
Why the state of Jharkhand?
Your Lordship, in IA paragraph number 4, it is stated that the appellant's written statement, wherein in para 13, it is stated that the vehicle in question was owned by J. Kachak, Jitu Kachak, 10 co-owners, Your Lordship. As such, all the said persons are necessary party to the proceeding, and Your Lordship, it is also stated that the vehicle in question was given by the government of Jharkhand to 10 Adivasis jointly for upliftment of their income under Samiti Adivasi Vikas Pariyojana, Your Lordship.
So the vehicle was not insured.
No, the vehicle was insured. It was a cooperative society, a scheme by the government of Jharkhand. This was given to them.
Yes. So what is your objection, Mr. Counsel?
Well, I have no objection. It would be rather beneficial for me rather.
Why do you? What is your contention in this appeal?
My submission in this appeal would be that in this case there was no permit, the first thing. Secondly, the driver was not having the valid driving license. That is to say, that license was there, but since it was a heavy vehicle, so it will not be covered by Mukund Devangan's case because the PSV endorsement was not there. Mukund, had it been a LMV, nothing would have been there. We had no case. But here in this case, it was a bus, a heavy vehicle. So the endorsement would be necessary. So that is my main contention in this argument. And the permit was not produced. In spite of that, the Honorable London Tribunal has fixed the entire liability, and we have deposited rupees 5 lakhs, and out of which 2 lakhs have been directed to be disbursed.
So you have to recover from the owner of the vehicle.
Yes, that is the thing. That would be my aid too, because that will be my in my aid. Because if she has prayed for that prayer for completing state of Jharkhand, perhaps she is helping me out.
Where is the bus now?
But I do not know where is the bus.
It must be scrapped by now.
So therefore, in this case, I will support my learned friend for implementing state.
The owners, where is the owner the registration document of the vehicle, the owner book. It stands in the name of 10% or a samiti.
But
No,
the RC book at the moment
how
I
state
don't.
of Jharkhand is a necessary party.
Department of Cooperative maybe made a different part.
Why Department of Cooperative is also necessary party?
As because your lordship, this was
State of Jharkhand or the cooperative department is absolutely neither a necessary party nor a problem.
well, I could not find the owner book and RC book at the moment. Let the records be called for, my lord.
A number, madam?
Yes, Your Lordship.
Your IA number?
IA number seems to be 2535.
Do you have
2535, Your Lordship.
do you have the copy of the owner book of the vehicle? Do you have the copy of the owner book of the vehicle? Yes, please switch
Well,
on your
at
mic.
the well, at this moment, I am not having any copy of the owner book, but this Jitu Kachhap, he was the in charge. He was the person looking after the affairs of the cooperative.
No, no. I want because of you bring on record the copy of the owner book of the vehicle.
Well, at the
Otherwise,
moment, I cannot find. But at the moment, I am not able to find it from my own record, Your Worship. The policy document is there. It shows Jitu Kachhap is the in charge and nothing beyond that.
in charge of the vehicle, but the vehicle stand registered in whose name?
But that would be ascertained from the RC book, Your Lordship.
You ascertain it, Mr. Lal. Give to the appellant will file a copy of the RC book, registration certificate book of the offending vehicle,
कॉपी ले लीजिए पहचान लीजिए
where it can be ascertained the owner of
But I would request my learned friend to give me the copy of the IA petition so that I can also find out.
the stuff. In this case, thereafter.
Serial number 5, MA number 598 of 60, Mr. Alok Lal, for appellant, Mr. A.K. Sani, Mr.
But in this case, but in this case, because of some personal difficulty, I could not file the substitution petition because my office, my friends, they are none of them are ready to come after vacation when I will filing it. Of course, I had taken time on the last occasion, but I could not file it because of the no helping hand.
What was the balance amount?
But that I also we could not calculate. My lord, by direct ballot we can deposit that amount. That direction may be given, your lordship.
No, I'm saying what is your
But that also I could not calculate, my lord, with utmost humility.
what is your contention in this appeal?
Yes, your lordship.
What is your contention in this appeal?
The contention in this appeal is that it was a case in which the owner has not produced the driving license and the permit. And the case of it is a case of injury.
As per the last order, my lord, he was directed to pay rupees 2 lakhs.
We have deposited. That balance calculation was to be made by me. I have already submitted.
It may be taken up on the next week, next after 1 week, my lord, so that I can also get the instruction. They have most probably deposited, my lord.
The parties pray for a week's time to seek instruction from their respective clients.
And in the meantime, I also see what is the balance.
My lord, I am appearing on behalf of OP number 2.
Next, after 1 week, immediately after reopening, it will be distributed.
Yes, oblige.
Serial number 6, MA number 59 of 17, Mr. Amitabh, Mr. Ashutosh Kumar Singh for appellant, Mr. Vinendra Varma, Mr. Sanjay Kumar Tiwari for respondent.
In this case, my lord, one IA has been filed for substitution in place of respondent number 7, my lord. As per information given by respondent number 5, 6 and 7 has been died, my lord. On 7/3, my lord. For that one IA number 4144 of 22 has been filed, my lord.
4144.
My lord. Yesterday it was filed, my lord.
Who is appearing? Who is appearing?
Mr. Sanjay Tiwari online, my lord. On behalf of respondent number 5, my lord. Paragraph 4 and 5, my lord.
My lord, I am appearing on behalf of the respondent number 5, my lord.
This application has been filed. Bring to delete the name of respondent number 6 and to substitute respondent number 7. It has been pleaded that respondent number 6 died on 6/10/2014 without leaving any year of success. Without leaving 6/4/2014, and
Years of respondent number 6 are already on record, my lord.
it is submitted that the years of respondent number 6 are already on record. Thus, the name of respondent number 6 needs to be deleted. Next paragraph. Further, it has been brought to the notice that respondent number 7 has died on 7/3/2022, leaving behind his son and daughters. A son and a daughter, namely Mohit Mehta and Prachi Mehta. It has been prayed that since the right to sue survives, respondent number 5 be substituted by respondent number 7 be substituted by his son Mohit Mehta and daughter Prachi Mehta. Details. After hearing the parties and after going through the record, I find that cause of action survives. The right to sue survives, and devolves upon the substituted respondents. Full stop. The substitution application is within time. Thus, this IA is allowed. Full stop. The name of respondent number 6 be deleted from the array of respondents. Full stop. The respondent number 7 be substituted by his son Mohit Mehta and daughter Prachi Mehta. Full stop. Issue notice to newly added substituted respondents. Ordinary process and registered company. 375 by an IA, it has been informed that so and so is dead. Thereafter.
Serial number 7, MA number 544 of 17, Mr. Ajay Kumar Singh for appellant, Mr. Vikas Kishore Prasad, Mr. Indrajit Sinha for respondent.
May I please, my lordship? I am favoring on behalf of the appellant, my lordship. My lordship, there are two IA, my lordship. One for limitation petition and one other is a substitution petition, my lordship. 764 is the limitation petition and 765 is the substitution petition, my lordship.
Who died?
My lordship, the appellant died, my lord. Murar Chaura. And the sole appellant, my lordship. And the substitute is his widow wife, my lordship.
When did he die?
My lord, he died, my lord, 14/1/19. 14 January 2019 को जो. I have stated, my lordship, and date certificate also in next, my lordship. Annexure 1, page 7, IA 765.
Application.
Lordship.
You have explained the delay. Okay. IA number 765 of 2020. This IA has been filed to substitute the sole appellant who died on 22, who died on 14/1/2019. Next, the counsel appearing on behalf of the appellant submits that the deceased has left behind his wife, sons, and daughter, namely so and so, paragraph 4. He submits that the right to sue survives, thus the deceased needs to be substituted. He further submits that there is a delay in filing the substitution application. As a lady, it took some time to contact the lawyer and file this for filing the substitution application. He also prays to condone the delay. First, counsel appearing on behalf of the respondent opposes the prayer. Next, after hearing the parties, I find that the right to sue survives and the delay in filing the substitution application is sufficiently explained. So thus, the name of the sole appellant will be deleted. Thus, the name of the sole appellant will be deleted and be substituted by his wife, namely so and so, sons, namely so and so, and daughter, namely so and so. Most of this IA stands allowed. Yes, what about the limitation? How many days?
My lord says 85 days, my lordship. 85 delays, my lordship.
Mr. Sinha, you are appealing? Amit Sinha?
Yes, Milord, I am appealing for this.
Controlling the delay. Yes. The delay of 55 days. After going through paragraph so and so, so and so, the delay is controlled. In this case, another name for admission.
Oblige, my lordship.
Oblige, my lords.
Serial number 8, number 573 of 70, Mr. Ashutosh Anand for appellant, Mr. Arvind
Lordship, in this case, I was only praying for not today, Lordship. The file was called by the regional office for taking some decision, my lords.
I have submitted one IA application, my lord, giving information that decimal 2, 6, and 7 has died.
It has been submitted that respondent number 2, 6, and 7 is dead. It has been submitted by Mr. Arvind Lal Learned, counsel appearing on behalf of the respondents. That is what is dead. On this aforesaid submission, Mr. Ashutosh Anand prays for some time. Mr. Period allowed. This case after summer vacation. Next.
Serial number 9, MA number 665 of 70, Mr. DC Ghosh for appellant.
Yes, Mr. DC Ghosh is ill and is not in Ranchi, as I've heard yesterday.
Who is appearing for the claimants? No, it appears this case is adjourned for 6 weeks.
Serial number 10, serial number 11, MN number 718 of 70, 6 cross operation 5 of 20. Mr. Ashutosh Anand for appealing first case, Mr. Arvind Kumar Lal for appealing second case.
My lords, in this case, in the first case, my lords, respond number 2 and 4 have died, my lords. I need to file the name deletion application, my lords. And cross objection copy, my lords, I need to get a copy of my lords.
Now, what is your ground with this appeal?
My lords. The appeal is concerned, my lords. My lords, amongst others, my lords, we are also claiming for right of recovery, my lords.
Contributory negligence.
My lords. My lords, even driving license is also a material factor, my lords, for right of recovery, my lords.
Who is dead?
2 and 4, my lords.
It has been submitted that the respondent number 2 and 4 is dead. First out. Mr. Ashutosh Anand next line. Mr. Ashutosh Anand prays for some time. Prayer allowed. There's this case after summer vacation.
Okay.
Serial number 12, MN number 346 of 80, Mr. DC Ghosh for appealing.
At John 6 weeks, no one appears.
Since Mr. Ghosh is not here, he will come after vacation, he opted.
Yes, after 6 weeks.
Serial number 13, MN number 429 of 80, Mr. Rohit Roy, Mr. Posto Panda for appealing.
Yes.
My lord, in this case, I am appealing on appellant, my lord. Lord, in this case, one IA has been filed, IA number 1958/2020 for limitation, my lord.
1958/2020.
Limitation of 37 days.
37 days. This, you are the revocation. So issue notice to the respondent.
3, 4, and 5, my lord, paragraph.
Yes?
Paragraph 3, 4, and 5 are
No, I'm not condoning the delay now. I'm issuing
the reason, my lord.
issue notice to the opposite respondent, opposite parties. Ordinary process requisites by 10th of June on the IA.
Serial number 14, MN number 214 of 80, Mr. Ashutosh Anand for appealing. Mr. Arvind Kumar Mato, Mr. DC Jha, Mr. Pratyush Kumar.
Made to your ship earlier notice was issued upon the respondents, my lord. There's a delay of 170 days, my lords. It appears that these respondents, there's some counsel appearing for the respondents owner as well, my lords.
Lords, I appeal, my lords, for respondent number 2, my lords.
I am for 3, my lord.
All of the respondents have appeared.
Yes, Lord.
The respondents have appeared in this case. Let's start. This IA has been filed to condone a delay of
170 days, my lords.
170 days. What is it? Why you have filed this appeal?
My lords, the claimant appeal for enhancement.
These are claimants.
My lords, we are the claimant.
Claimants appeal for enhancement.
my lords.
Who is the insurance company?
Yes, Lord.
What do you say?
Lord, the future prospects have perhaps not been granted. And the rest of the things, Lord, the conventional head, as far as the convention.
There is a right to recovery.
Yes, Lord, there is a right of recovery. That's the difficulty. If the owner agrees, I think whether he will agree for settlement or not.
Who is the owner?
Owner has appeared.
Lords, I appear for the truck owner, Lords.
Who is the owner of the tractor?
Owner of the tractor is
Lords, the owner of the tractor.
There is partnership, my lord.
You are for Mr. Mato? You are appearing for?
Respondent number 3, my lord.
Who is respondent number 3?
Respondent number 3 is Aditya Kumar Mahato.
You are the owner of the tractor. You are the owner of the tractor.
My lord, there are partnership. I was left with this partnership earlier itself, my lord, with an agreement. But
who is the registered owner of the tractor?
My lord, 3 is the registered owner. 3 to 7 are the registered owners of the tractor, my lord.
Who is appearing on behalf of 4, 5, 6, and 7? Who is appearing on behalf of 4, 5, 6, and 7? I'm condoning the delay.
My lord.
Please discuss at the hearing for admission. As the notices, the office is reported that the notices have been validly served.
Serial number 15 is wrongly listed. Serial number 16, MA number 465 of KB, Mr. Manish Kumar for appellant, Mr. Sanjay Kumar, Mr.
May I please, my lord, there is a delay of 17 days, my lord. Notices were earlier issued. 27 days delay there.
What is your ground?
Ground is, my lord, specific defense was taken that driver was not in possession of valid driving license and vehicle was being plied without permit. Owner appeared and contested the case but did not rebut those and did not produce those documents. And that one issue was framed that whether the driver was having in possession of driving license or not. And it was, my lord, decided against the company on the ground that no evidence was laid, ignoring the fact that despite specific government, no copy of driving license or permit was produced by the owner. Notices have been issued and the name of 2 lawyers is appearing for us. All the parties have appeared. We are not challenging the quantum.
Can you challenge this issue also when the driving license number was granted, was mentioned in the written statement?
Here, my lord.
Come to issue number 4, page 27
Yes,
in a paper.
My lord. Driving license number is there, but one more point is there, my lord, permit.
Where have you taken the ground of permit?
My lord. I have filed the written statement also. Copy of written statement is on record, my lord. Just a moment, answering.
What was the vehicle?
Passenger carrying auto, my lord.
Auto?
Yes, ma'am.
You didn't have a permit?
No, my lord.
Is it necessary for auto to have a permit under the Motor Vehicle Act?
Yes, sir. Passenger carrying here in Ranchi also permit is required, my lord.
Under which provision of the Act?
For that, my lord, I will show my lord on different date. Today I am not ready with that. Today only for limitation, so I thought.
Show it, show it.
I'll show, my lord. let it come in only after vacation manner also.
And also tell me whether if the permit is not there, is it a fundamental breach?
Yes, madam, there is judgment of Honorable Supreme Court.
Bring that. Show me that. When do you want? After summer vacation?
Yes, I'll show that, madam. Yes, after some. Today, since it was only for limitation, so I thought
Limitation
my
control.
mistake.
Limitation control is this case. Uh, just a minute. Anyone has appeared?
Yes. Name of two lawyers is appearing. There are only two parties. One is set of claimants and the other is owner.
No one appears on behalf of the respondent. Mr. Manish Kumar submits that the delay was unintentional.
27 days delay.
The 27 days delay is unintentional. He explains by filing this petition from paragraph to paragraph 7, so and so to so and so, the delay has been explained. I allowed this discussion under the heading for admission. You tell me what are the provisions?
Milo. Like.
Serial number 17, MN number 494 of 18, Mr. Alok Lal for appellant, Mr. Shelkroser, Mr. Rahul Dev, Mr. Om Prakash for respondent.
Well, in this case, it has been placed for condoning the delay of 28 days. The parties, they have appeared, Your Lordship, as per the cause list.
Yes.
I'm appearing for respondent number, Your Lordship, respondent number 567, Your Lordship.
What is your ground, Mr. Lal?
Well, the ground in this case is that it was the road roller not insured for under the Motor Vehicles Act as per the section 147. No policy for third party was taken by the insured.
What was the contract? No policy was taken.
No policy was taken. It was a contractor's plant and machinery policy, which is outside the purview of the 147.
Well, the policy was exhibited?
Yes, Your Lordship. Exhibit X by 3.
Delay control in view of statement So the insurance was not under the MV Act?
MV Act.
Okay. It was a general insurance for the purpose of?
Yes.
For the
purpose of safety and security of the
security
road
of the
roller. Machinery.
Yes.
Serial number 18, MN number 530 of 18, Mr. BC Jha for appellant.
Lordship, in view of the order, the notices were filed on respondent 1 to 7 by ordinary and registered date, Your Lordship. But as per causeless appearance of
7 is dead. Respondent number 7 is dead. The officers reported that respondent number 7 is dead.
Lordship, 7 is driver, Your Lordship. Respondent 7 is driver, Sitaram Majhi.
Mr. V.C. Jha, appearing on behalf of the insurance company. Then a counsel appearing on behalf of the insurance company submits that no relief in this appeal has been sought against respondent number 7. Yes? You are seeking any relief?
Lordship?
Are you seeking any relief against respondent number 7?
No, he is a driver. उसके against तो कोई relief नहीं. No relief. His name can be expunged.
He submits that his name can be expunged. Considering his submission, the name of respondent 7 is hereby expunged. What's the notice? The officers reported that notice issued to the other respondents have been validly served. What's the Next, this IA has been filed to condone the delay of
79 days.
79 days. After going to paragraph so and so, delay conclude. What is your ground?
Ground for condonation, Your Lordship. That is
No, ground is appeal.
error 3, Your Lordship.
Ground in your appeal.
The ground of my appeal is that 5 laborers were traveling in a tractor. So traveling on a tractor, they were not covered, Your Lordship. And there is a direct judgment of the Honorable Supreme Court to this effect. They are not covered.
Under the heading for admission.
Serial number 19, MA number 548 of 80, Mr. Alopo for appellant, Mr. MP Lal, Mr. Rajiv Kumar Sir, Mr. Ray Rajat for respondent.
Well, in this case, perhaps it is also for the condoning the delay, and notices were issued on the respondents. Some of them have appeared. I'm not sure about the status of respondent number 5, the owner.
What is your ground?
Well, it was a fake policy. It was a fake policy.
You have led evidence.
Yes, Your Lordship. We have got evidence. Those things are on record. But those have not been considered. So therefore, in this case, the LCR also may be called for.
What is the finding?
Yes, Lord. That finding is strictly against me. Finally, strictly against me. Issue number 4, whether the truck number such and such was involved in the accident. Whether the truck is valid permit at the time of accident. Now the copies were filed by the policy by the claimant, which we have disputed.
What they have filed, what the dispute is not a rebuttal evidence.
But I would like to indicate from the various documents which we have filed by before the learned court below. So therefore, the records may be called for. By affidavit, the officer of the insurance company has filed specific affidavit to this effect. Those things have not been considered by the learned tribunal.
Mr. Counsel, from your side, you have not exhibited any documents, nor you led any evidence, oral evidence.
Kindly, this is what इसको फिर छुट्टी की बात कर दिया पढ़ कर देंगे हम जो करना हो करिएगा डिस्मिस होगा I'll let the delay be conducted, put up this case after admission.
My Lord, I am appearing on behalf of respondent claimants, my Lord.
Delay is continued. This case under the heading for admission. In the meantime, call for the local records.
Obliged.
Serial number 20, MA number 555 of 80, Mr. A.K. Sahni for appellant, Mr. Sindar Majumdar for respondent.
Your Lordship, in this case, I am appearing on behalf of the respondent, Your Lordship.
Yes.
I've just located just to accept my wakalatnama because there was an preemptive order for them to remove the defect, Your Lordship. They have not removed the defect.
It has been dismissed.
No, Your Lordship, it's not.
We have removed the defects, Your Lordship. Else.
Why it has been listed today under the heading for orders?
They have filed IA, Lordship. For on IA, it has been listed, Your Lordship.
Khali, Your Lordship, para 8-9 dekha jai, Your Lordship. Since the respondents, when they came to know about the filing of this case, they have.
Okay, this
since the notice have not been issued, so that.
Accepting the wakalatnama.
Yes, Your Lordship. Only for accepting the wakalatnama.
What is this case?
In this case, Your Lordship, the
opposite parties, they have filed a probate case, Your Lordship. In that case, we had appeared, and thereafter we could not appear, Lordship. Then the ex parte order was passed. Against that, Your Lordship, on Order 9, Rule 13 application was filed. That was also dismissed. Against that, we have filed an appeal. That was also dismissed, and both the orders are under challenge before this Lordship, subject to correction by my learned.
No, Your Lordship, this is the case, Your Lordship.
देखिए, this IA has been filed by the respondent, praying therein to direct the registry to accept the wakalatnama filed on behalf of the respondent. Mrs. Majumdar submits that the wakalatnama was filed before issuance of the notice by this court, as the respondent as a suo motu appeared, coming to know about filing of this case. Mr. Vikash Kumar has got no objection if the respondent appears so. Next, considering the submission, I direct the office to accept the wakalatnama and place this case after vacation. Vacation. The name of the respondent should be reflected in the cause list. Cause list में है नाम. Name has been reflected in the cause list.
Yes.
Are you supposed to?
Obligation.
Under the heading for admission, serial number 21, ML number 314 of 50 with serial number 22, ML number 422 of 70, Mr. Anjali Kumar, Mr. Chandrajit Mukherjee for appellant in first case, Mr. Alok Raj for appellant in second case, Mr. P.S. Pati, Mr. Asadul Haq and Mr. Arvind Kumar Raj for respondent in first case.
The possibility for settlement in National Lok Adalat, my lord. I am for the claimant.
Mr. Das?
Lordship, serial number, Lordship, kindly see the last order, 28/3/2022.
This is 22 and 20, 21, 22.
Yes, in serial number 21, Your Lordship. In both the cases. It was a case where, Your Lordship, the driver was implanted and same driver was implanted in several other.
Okay.
We have served the copy upon the state, Your Lordships.
Your Lordship, I am appearing for the state in this case, Your Lordship.
GR किसका रिकॉर्ड आया है? $31 आया है, $375 भी आया है. दोनों एक साथ हुआ था ना? In both the cases, the driver were implanted. Which one, Mr. Das?
So in both the cases, the driver was implanted, and in fact, as per my inspection, in the second case also, the driver was the same person. We have given the driver. Yes.
Who is the driver?
Manoj Kumar Das.
What is your case?
My case is, the Lordship, that this driver has been implanted and the same person is the driver. In several other claim cases, we have given the number, Your Lordship, at page 12.
How many claim cases? He is the driver?
Lordship, 3 cases I have given a number, and in the second case, most probably, Mr. Alok Lal has given the number of 8 cases, most probably. In serial number 22.
Tomorrow.
As you Lordship.
Tomorrow, physical court.
serial number 23 with serial number 24, MA number 52 of 60 with MA number 545 of 50, Mr. Nikhil Ranjan for applying in first case, Mr. Tarun Kumar, Ms. Vani Kumari for respondent for applying in second case.
Your Lordship, in this case, there was an order to pay 1 lakh rupees on the last occasion, my Lord, on 29/3/2021 by the owner. I am the appearing for owner, my Lord. Your Lordship, this amount could not be deposited before the court below, but my client has given me the check sent through courier. I have the check and the check number.
No, there are two cases.
First case is by the owner, 52 of 2016, my Lord.
For enhancement.
The first case is by the owner for the second case is for enhancement by claimants.
You are the owner.
I am the owner. First case is for by owner.
Who is for the claimant? Why 1 lakh?
Yes, Your Lordship. I am appearing on behalf of the claimant, Your Lordship.
For what purpose? There's no order.
Your Lordship.
Not on the last occasion, it was on the last date. In the earlier occasion, the case was wrongly listed.
Yes, Lord. Yes, Lord. Last date, 29/3/2022.
It's a death case.
Injury,
No.
minor injury, my Lord.
What is minor injury?
No.
From the record, Your Lordship would find that it's from the record. If Your Lordship, we will argue. Your Lordship would find that there is no injury certificate, there is no disability certificate. Injury is very minor in nature. This is my submission, and they have come before this honorable court for enhancement.
Yes, Mrs. Vani Kumari, are you satisfied with this 1 lakh rupees? Will you be satisfied?
Yes, Your Lordship, but we are not in contact from last 1 month. I'm trying to contact her. She was handicapped, but still she was working as a maid because she was working for a livelihood, Your Lordships. Yes, Your Lordships, but I will contact in a next date may be given, Your Lordships.
This case under the as the party case.
Lordship, one more order, 9/2/2020 also be seen, Your Lordship.
What is it?
That was passed, my Lord, to file an affidavit regarding my assets, and thereafter, Your Lordship asked me to deposit 1 lakh. So,
just a minute. The matter can be resolved in the Lok Adalat.
yes, my Lord.
Yes.
I have the check.
The parties submit that the matter can be resolved in the Lok Adalat. Considering the submission, refer the matter to the Lok Adalat. Who is that? Which place? Case?
52 of 16 in that, my Lord.
Which place? Case is of which place?
Gumla.
Gumla, Your Lordships.
Gumla.
Member Secretary Jalsa is a order Raj Vijay is directed to establish contact with the claimants. Through DLSA Gumla, and if possible ensure appearance of the claimants as the owner who is ready with a check of rupees 1 lakh.
Yes, I have it.
Look at that. Let this order be communicated immediately to Member Secretary.
Obliged, my Lord.
Serial number 25, MA number 11016, Mr. Arvind Kumar Lal for appellant.
My lord, this appeal for enhancement, my lord, I am not aware that who is appearing for United India. Nobody's name is coming. Although I am interested for.
Not served a copy to anyone.
I'll serve by today evening, my lord.
Today evening. It's for enhancements.
My lord.
Yes, United India. Mr. Manish Kumar. Mr. Manish Kumar. Where is Mr. Manish Kumar? Tell him to come join the proceedings.
My lord. Perhaps Mr. Alok Lal is also for United India. Perhaps.
Mr. Yes, Mr. Lal.
My lord.
No,
Perhaps Mr.
there-
Alok Lal is also for United India.
Yes, I do appear for the insurance team, but
See, this is copy for enhancement.
let him give me the copy. We have not examined the matter. Today he will be serving me the copy only.
Yes, just 2 days are enough.
Well, that will not be possible because we are not. Next लोग आधा तो हम लोग कर लेंगे देख लेते हैं क्या होगा ना. He should have given me the copy much earlier.
You say that it is not possible.
No, this will not be
You say
possible.
that it is not possible.
It will not be possible. It is
Okay,
only
let the
one
matter
day.
be taken up after vacation, my lord. I will serve the copy today itself.
Listen to the order, Mr. Lal. Both Mr. Lal listen to the order. Mr. Arvind Lal, appearing on behalf of the appellant, submits that it is not. He will serve a copy of the memo of appeal along with the judgment to Mr. Alok Lal today itself. He also prays that the matter, since the appeal is for enhancement only, then let the matter be referred to the Lok Adalat. Next paragraph. Mr. Alok Lal submits that it will not be possible to scrutinize the file and come to a conclusion as to whether this matter can be resolved or not. Full stop. Resolved or not during this short period. Full stop. The insurance company is which company? United India. Branch manager, which place? Insurance policy company.
हाँ बोलिए. आप बोलिए जल्दी बोलिए. हाँ वही रहेगा.
Package policy, public carrier. Issuing officer, Subhash Chak Ramgarh. Ramgarh Cantonment Branch. After going through the record, I find that this claim application has been filed for enhancement only. First up, the next Lok Adalat, National Lok Adalat is due to be held on 14. First up, thus I direct the competent officer of United India Insurance Company to remain present in the Lok Adalat along with the file of this case for exploring a possibility of settlement. Let a copy of this order be immediately handed over to Mr. Alok Lal and Mr. Arvind Lal. Tell him to appear.
They will appear. They will be appearing in number of cases. This will also be.
So it can be easily resolved.
We'll have to see, but I cannot. I'll talk to them and we'll let.
Yes. Mr. Arvind Lal, also you take some steps.
Yes, my lord. My lord.
Yes. Next.
Serial number 26, MA number 228 of 16, Mr. Samuel Gowri for appellant, Mr. Manish Kumar for respondent.
In the last occasion, Your Lordship, I call for the LCR, Your Lordship. May I place in the physical day, Your Lordship? I've gone through the LCR, Your Lordship.
You have gone through?
No, Your Lordship, I have not gone through it. It's that it's gone for the physical day, Your Lordship. I have gone through the.
This is by the
My lord,
Clement.
the claimant wife and mother.
this is for enhancement.
Yes,
Yes,
lordship, for
Lordship.
enhancement.
In the last occasion, Your Lordship, I called for the LCR, Your Lordship.
Right to recovery is there or not?
No, yes.
No.
Right. No, lordship. Right. No, lordship, it has been mentioned that issue number 15, lordship, that
Issue number
lordship, that was issue number 15.
right to recovery is there. Which for the owner?
Yes. Yes, lordship. Issue 15. My lord, entire calculation has been, we are challenging the calculation, which has been determined only on the basis of 3,000. But the young man, and he was a driver and earning 6,000 rupees, and on what basis he has calculated 3,000?
Mr. Amrish Kumar submits that he wants to produce the lower court records, especially the evidence of the parties, as the quantum as the calculation of monthly income has been challenged by the claimants. He said, full stop. Let's this case after summer vacations on a physical working day.
Obliged.
Physical working day.
Serial number 28, MA number 396 of 16, Mr. M. V. Lal for appellant, Mr. Pratik Singh, Mr. Alok Lal, Mr. T. Kumar Singh, Mr. H. Roy for respondent.
My lord, I am appearing on behalf of appellant, my lord. My lord, on the last occasion, the insurance companies are directed to take instruction if 4 lakh could be paid over and above the amount already paid. In fact, my lord, 2 vehicles were involved in the accident, and the liability to pay the compensation has been apportioned between the 2 insurance companies.
Yes, who are the insurance companies?
But I am appearing for the national insurance company. I had a discussion with my officers. They say that if they are ready to pay 2 lakhs more because the liability has been apportioned, the Bajaj, it is for the Bajaj to say.
Who is the Bajaj?
Mr. S.J. Roy is there.
Where is Bajaj?
I also do appear, but in this case, I am for the national insurance company. So I will be siding with national insurance.
Where is Mr. Bajaj? हमारा बजाज कहाँ गया?
हमारा बजाज गायब है, लालपुर चौक में है.
Where is Mr. Roy? Tell him.
But in fact, the Bajaj, what we are feeling the difficulties because earlier one officer is there, but he has been not been asked to do any high court job. So it is being controlled either from Lucknow or from Patna. So that is the difficulty we are facing for Bajaj. So Mr. Roy, I'll ask Mr. Roy. Let me be passed over. So far my contention is concerned, we are ready.
So tell one of your officers from Bajaj to come from the local adat. They should give an undertaking that
let this matter be passed over, my lord. Let me be passed over. Mr. Bajaj, Mr. Roy must have received instruction. He might be stuck up in some other court.
Maybe. Pass over.
Pass over.
Pass over.
But I am calling Mr. Roy.
Yes.
Serial number 29, MA number 408 of 16, Mr. D.C. Ghosh, Mr. Suraj Singh, Mr. Indrajit Sinha, Mr. Amitabh Prasad, Mr. Ankit Vishal, Mr. Ajay Kumar Shah for respondent.
No one appears. Case is adjourned. We'll decide after summer vacations.
serial number 30 with serial number 31, MA number 47016 with MA number 471 of 60. Mr. Vijay Kumar Sharma for appellant in both the cases. Name of Mr. Arjun.
Yes, Mr. Roy, SG Roy. Mr. SG Roy.
Lordship.
Did you take instruction with your Bajaj? 2 lakh rupees? Did you take instruction in that case? If your client is ready to settle the amount by paying 2 lakhs from your side?
Item number 28.
Yes,
As you can see, the portion with National and Bajaj. So my Bajaj has been 2 lakh.
Yes, Mr. Roy.
Lordship, we have deposited the payment and there are two vehicles involved. One is
On the last occasion, it was said that if 4 lakh rupees in all is paid, they will be satisfied. Now 2 lakh rupees by Mr. Alok Line's client and 2 lakh rupees by your client. Are you agreeable for this?
I have not received the instruction till date, Lord. I will send them message, but didn't receive them. I will ask.
Call them to appear, make them appear, make in the Lok Adalat.
Lord.
Mr. Alok Lal submits that there is an apportionment of the amount of compensation, and his client is ready to pay 2 lakhs more. Full stop. 2 lakhs more as इसमें cutting है the claimant submitted that they will be satisfied if 4 lakh rupees is paid in lump sum. 4 lakh rupees more is paid in lump sum. Full stop. Mr. Alok Lal submits that his client is ready to pay 2 lakh rupees, which would fall in the share of his client. Full stop. Next paragraph. Mr. Siddharth Roy submits that he has not received any instruction. Full stop. Considering the submission, this court feels that the matter can be resolved in the Lok Adalat. He listed before the Lok Adalat on 14th. An officer from Bajaj Alliance Insurance Company should remain present on that date. A competent officer, remain present on that date. Tell them to appear.
Lord.
Next.
Serial number 30 with serial number 31, MA number 470 of 60 with MA number 471 of 60.
Mr. Alok Lal, you also convey to Bajaj Alliance.
I'll try, my lord. I'll try to.
Have a talk with Mr. Roy.
Yes, we'll. I'll talk to him.
The state in this case, Lord.
What is this case about? Any certificate has been filed for enhancement.
Yes, Your Honor.
The vehicle belongs to whom?
Vehicle belongs to city.
Vehicle belongs to whom? Government vehicle. Where is Vijay Kumar Roy? Sharma.
Lordship.
Yes, Mr. Sharma. You have come for enhancement.
Lordship.
What was the amount paid? 4,82,000. Death of whom?
First case, Your Lordship, injury case, Your Lordship. MA number 470, Your Lordship.
And the second case?
And next case, Your Lordship, death case, Your Lordship.
Arising out of the same accident?
Second case, Your Lordship, death case, Your Lordship.
Arising out of the same accident. Yes, it is the vehicle of the
Arising
state.
out.
Yes, my lord, I am for the state in this case. Lord.
Mr. Sharma,
Both cases.
the vehicle, offending
State
vehicle.
vehicle.
State vehicle. Yes, Mr. Deepak Dubey, call your officer. Lok Adalat.
My lord.
State. The party submits that the matter can be resolved in the Lok Adalat. It has been submitted that the vehicle belongs to the state, and the state has to pay the compensation amount if at all it is enhanced. And full stop. Considering the state submission, I direct the let me place this matter before Lok Adalat. The matter is referred to the Lok Adalat. Which department's vehicle?
My Lord, Deputy Commissioner Chatra, Your Lordship, and CDPO.
A competent officer from who is a competent officer
My Lord,
to
CDPO, Your
Deputy
Lordship.
Commissioner is Lordship.
Under
Deputy
who is the competent officer to enter into compromise in the state?
Deputy Commissioner Lordship, perhaps Lordship.
Perhaps it is the state we will know. Who is the officer? Tell me.
My Lord, in this case, Your Lordship, direction may be given to Deputy Commissioner Chatra, Your Lordship.
In any dispute with the state, who is the competent officer to enter into a compromise? Tomorrow, I don't want that anyone to say that this officer was not competent to enter into a compromise.
But in this case, Your Lordship,
Lordship, it is kind of the parallel Lordship, internal page Lordship. According to the pleading of the claimant estate of the Jharkhand for the Deputy Commissioner Chatra and CDPO Patapur, both Your Lordship.
Mr. Counsel, understand my question first. Then give a reply. I'm asking you who is a competent officer on behalf of the state to enter into a compromise in a financial matter. Because tomorrow, if the deputy commissioner of the city come out, then your finance raise a question.
I have to seek instruction, Your Lordship.
For
this, I have to seek instruction, Your Lordship.
Competent officer of the state who have competence to enter into a compromise with a party in respect of financial matters should be present in the local adalat in this case.
Manner.
Resolve these disputes. These are the matters should be resolved.
Manner.
Serial number 32, MA number 572 of 60, Ms. Sunita Oja for appellant, Mr. Yogendra Prasad for respondent.
Yes.
I am appearing on behalf of the appellant, my lord. Main ground in this case are the deceased have nothing proof of earning. And court below has considered 8,000. Second ground is also considered personal expenses, which is fit and proper, that is 1/3. But court below has considered 1/4.
How many dependents? 4 dependents. Four dependents. So 4 dependents would be?
Four claimants, sir.
4 claimants would be 1/4. There's no wrong in it. Now you say the quantum.
Yes. That is also very high and considered the 8,000 per annum.
Let us see what is the evidence you have led.
Milords, one thing I want to clarify, Milords.
Yes.
Here are my lords, 5 respondents, my lords, and 1 to 4 are the claimants, my lords, and I am the respondent number 5 only, my lords. Now, whether the claimants are representing or not, that may be seen, my lords.
Mr. Prasad.
Yes, my lord.
When do I need to hear the respondent? Tell me. In what situation and when do I need to hear the respondent? When? Tell me. Tell me when. In what situation the respondents need to be heard?
My lord, when the case will go against their interest.
Yes. Let me see.
Yes, my lords.
Dismissed, then what is the necessary to give pain to those respondents to engage a lawyer and appear?
Yes, my lords.
Let me see the evidence, what has been led and how cross-examination was conducted. Because Madam Oja cannot revive a dead case if there is no evidence led in the trial. However, whatever if the proper evidences are not there, or cross-examination by her client before the court below, she cannot take all this ground. This is when the businessman was earning 8,000 rupees per month. Let us see the exhibits. How much paid?
5,50,000.
You know, madam, there is a judgment of the Supreme Court recently which says in the death of a 12-year boy, 5 lakh rupees has to be paid. So the amount is only 5,50,000. So what is wrong in it? Very good judgment. Right. Your motion will be correct. Yes, yes, yes. Yes, yes. Right. 6,43,000 has been paid.
Award amount is 6,43,000.
6,93.
50,000 already paid ad interim award.
That I'm asking about the total.
Oh, sorry, lots.
Total is 6,93. What are the age of the? What is the age of the?
60 years, Lordship.
No, no, the age of the dependents. This
Dependents.
independence.
Not mentioned also.
%9 interest.
Yes, that is also high also.
What is the report of Jharkhand? Because the white order dated 23/2/2022, the Jalsa was directed to establish contact with claimants and inquire and ascertain whether they need any legal assistance, as they were not appearing in this case. First up, the next part, the office report dated 9/5/2022 suggests that no report has been received yet from Jalsa. Member Secretary Jalsa is directed to comply the order dated 23/2/2022. That this order be immediately is communicated to Member Secretary Jalsa. Let's discuss on Friday.
Serial number 33, MN number 574, 60, Mr. DC Shah, for appellant, Mr. K. Nanda for respondent.
In this case,
Lordship, last order may kindly be seen, Your Lordship.
that is, when last occasion, Your Lordship, an order was passed, Your Lordship directed me to file an affidavit of the owner of the vehicle with respect to his property.
Yes.
My Lord,
Mr. K. Nanda waits for 1 week's further time to comply the order dated 13/12/2021. Full stop.
Lordship, second week में रखा जाए because I have to go for an operation. Yes. August.
Serial number 34 with serial number 35. Serial number 34 with serial number 35, Mr. K. Nanda for respondent. Mr. DC Shah, for appellant, Mr. K. Nanda for respondent. Mr. DC Shah, for appellant, Mr. K. Nanda for respondent. Serial number 34 with serial number 35. Serial number 34 with serial number 35, Mr. K. Nanda for respondent. Mr. K. Nanda for appellant, Mr. K. Nanda for respondent. Serial number 34 with serial number 35, Mr. K. Nanda for appellant, Mr. K. Nanda for respondent. Serial number 34 with serial number 35, Mr. K. Nanda for appellant, Mr. K. Nanda for respondent. Serial number 34 with serial number 35, Mr. K. Nanda for appellant, Mr. K. Nanda for respondent. Serial number 34 with serial number 35, Mr. K. Nanda for appellant, Mr. K. Nanda for respondent. Serial number 34 with serial number Sharma for appealing in first case, Mr. Amit Kumar, Mr. Ajay Kumar for appealing in second case.
Instant appeal has been filed by the claimant's appellants, Your Lordship, for enhancement of the compensation amount, Your Lordship. In the MA number
Lordship,
686.
in serial number 35, I am appealing on behalf of Tata AIG General Insurance, Lordship. Lordship, I have given NOC to Tata AIG, Lordship. I have resigned from the panel of the Tata AIG, Lordship, and the said file has been allotted to Mr. Ashutosh Anand, Lordship. And I have handed over the file to
Yes,
Mr.
Mr. Ashutosh Anand. Where is Mr. Ashutosh Anand? Ashutosh Anand, where are you? Where is Ashutosh Anand? Yes, Mr. Sharma, what is the ground? Your application is for enhancements.
Lordship. This Lordship, this is was doing a job, Your Lordship, auto electrical tank and Durgapur, Your Lordship.
What is the ground in the appeal of the insurance company?
Insurance company, Lordship, this is was sitting on the roof, Your Lordship.
Rooftop?
Roof of the bus, Your Lordship.
Right to recovery granted or not? Who is the owner of the vehicle?
Ragini Kumar Singh, Your Lordship. The respondent number, my picture 1, Your Lordship. Ragini Kumar Singh, wife of the Sasif. And this is was sitting, Your Lordship. It has come in the para 12, Your Lordship. The last line, Your Lordship. Conductor of the bus said to the Samsul, took place on the roof of the bus, Your Lordship. Mohammed Samsul was over 18 years old. He was working as the electrical, mechanic, fuel, auto electrical, Dankan, Durgapur Road, Hogli, West Bengal.
No court record is here. Who is the owner? Who is anyone appearing for the owner of the vehicle? Okay, MA 8 of 2018. Issued notice to
I was appeared, Lordship, on behalf of the Army Kumar, Your Lordship.
owner has appeared.
Sorry, Your Lordship.
Owner has appeared, Mr. Sharma.
He was the insurance company.
Issue notice to respondent number 7. Registered ordinary both process requisites to be filed by 10th of June. This may be here. MA 686 of 2017. Issued notice to the respondent number 1. Registered ordinary growth process requisites by 10th of June. Call for the lower court records.
Under the heading for hearing, serial number 36, MA number 417 of 15, Ms. Ritu Kumar, Mr. Vikas Kumar for appellant, Mr. Mahesh Tiwari for respondent.
May it please the court, please.
Yes, choose for the appellant. Serial number 36.
My lord.
Which for the appellant? Which for the appellant? Serial number 36. Possible.
Serial number 37, MA number 435 of 50, Ms. Nihala Sharmi, Mr. Chandra Kumar, Mr. Bahar Alam, for appellant, Mr. Alok for respondent.
My lord, with consent, my lord, this matter come up after the vacation, your lordship. I have not read it, my lord, and I have taken the consent of my senior advocate, my lord, after the vacation.
On the request of Mr. Alok Lal, let's discuss after vacation.
Your lordship, I am for the appellant. My appearance may be noted. Much obliged.
Yes, give your slip. Send your slip.
Serial number 38, MA number 580 of 50, Mr. DC Ghosh.
My lord, let this matter also come after the vacation. Mr. Ghosh is not here, your lordship. And the next matter also, my lord.
I was only praying if a copy of the petition is granted to us, my lord. We are appearing on behalf of it.
There is no matter left. इसको भी जो है ना with Mr. Yes, next.
Serial number 39, MA number 548 of 60, Mr. ASAR, Mr. Anurag Kashyap.
My lord, in this case also, Mr. Ghosh is not here, your lordship, one of the respondents.
Yes, where is Mr. Dayal?
Your lordship, the matter has to be argued by Mr. Anurag Kashyap, your lordship. I am praying that he, due to his personal difficulty, he has gone to. Your lordship.
Where?
He has gone to hospital, your lordship, for the checkup of his daughter, your lordship. Kindly it may be posted at 2:15, your lordship. He is ready. He is ready to argue the matter, your lordship.
Yes, Mr. Lal.
Mr. DC Ghosh is one of the respondents, your lordship, and he's in difficulty, so he's not in Ranchi, your lordship.
What is the matter? Let me see.
Sorry, your
This is for
lordship.
enhancement. This is most probably for enhancement. Let me see. Compensation case dismissed. What, bro? LCR will. Mr.
Yes,
Lal,
Lordship.
Mr. Lal, the vehicle was a passenger carrying vehicle. The insurance is for the passenger carrying commercial vehicle. Now, the vehicle dashed with a tree, resulting in injury and death. The insurance of some of the passengers. Now, the tribunal has held that there were no negligence on part of the driver of the passenger carrying vehicle. There was a mechanical fault which led to the accident. So, application dismissed.
But then this is a matter of remand. Then this is a matter of remand. It cannot be decided here.
First of that is a later part. The first part is this judgment cannot be sustained. Accident admittedly has arisen out of use of a motorcycle, motor vehicle. Yes, Mr. Lal.
Alright, that is true, Malad, but subject to correction, Malad.
How can the claim application be dismissed? How can the claim application be dismissed on this ground?
No, it could not have been dismissed. At least the liability should have been fixed upon the owner in this case. At least
The question of the liability.
is that is what I'm submitting, that it should. It is a case of remand. This is a case of remand because there are certain judgments in which the mechanical fault for that insurance company has not been held liable. There are certain judgments.
No. Just a minute.
So it is a case of remand. It cannot be decided here, Malad. It is Saturday. My lord can set aside the award and send it for review, reconsideration, which cannot be decided here. Even if what would be the quantum, what was their income, those things could be decided by the tribunal by the trial.
No, evidence is already there.
But then let it come after the vacation. Well, Mr. Ghosh will be there. I am not the master of this brief. On his behalf, I am making a submission. So whatever has been followed from the lordship's mouth, it is a case. It seems that it is a case of remand.
Valid driving license is there.
The status of license, status of permit, the status of this policy.
Evidence was already recorded.
Something might have come against it with respect to the policy and the this thing. The permit and driving license. Therefore, since the case was dismissed, therefore the insurance company might not have challenged it. The finding, none of the finding would have been against him, but because the case has been dismissed, the insurance company preferred not to file an appeal because I'm not aware of the brief, I'm not aware of the facts.
Who is the owner of the vehicle?
Someone is appearing, Your Lordship.
Malas, I am appearing. Malas.
Yes.
But the vehicle is insured, Malas, and the evidences has come out that initially the case has been Malas instituted under section Malas 304A Malas for the rash and negligent driving. Later on it has been decided कि वो धीरे चल रहा था डैश कर दिया. ऐसा नहीं कि मैकेनिकली कुछ उसका इन्वेस्टिगेशन हुआ है किसी एक्सपर्टीज से किसी टेक्निकल पर्सन से और ये बोला कि टेक्निकली मैकेनिकल फेल्योर है. हेलो. मैकेनिकल फेल्योर का ड्राइविंग लाइसेंस इज वैलिड मतलब.
Valid. Ms. Alok Lal appears and submits that Mr. Devesh Ghosh, who is the learned counsel, supposed to appear in this case on behalf of the insurance company, is because of health ground has not come to court. Is not appeared in this case.
Because of some personal reasons, Your Lord, not his personal reasons.
Because of some personal reasons has not come. Has not couldn't attend this hearing. Has to be placed for some time. After considering his submission, this case is adjourned for to be adjourned to be listed after the some applications. Serial number 38.
Serial number 40, MA number 655 Mr. Vijay Kumar Sharma for appellant, Mr. Gautam Rakesh for responding.
Yes, Mr. Sharma. Where is Mr. Sharma?
Yes, Mr. Sharma. In the this case, Your Lordship, learned tribunal has Lordship, in this case, Your Lordship, appellant has filed the appeal, Your Lordship, in the against the tribunal, Your Lordship. Tribunal has dismissed the claim of the petitioner appellant, Your Lordship. On the ground, Your Lordship, the dead body was recovered on the railway yard, Your Lordship.
Madad.
Yes.
My lords, we have got the file, my lords. However, my lords, at page number, running page number 2, my lords, of the order, my lords, the impugned order, my lords. Lords, references have been made to certain exhibits, my lords, and it seems, my lords, that the statement of one particular person, my lords, will be necessary, my lords, because he has given a statement, my lords, that the deceased person, he had gone to the railway siding in order to relieve himself, to answer the call of nature, my lords. But I may be given some time to procure the LCR, my lords, because my argument, my lords, it may be in the lines, my lords, that was
I fail to understand why you people are appearing without the entire brief.
my lords, we have just been handed over the a copy of the MA, my lords. It just contains the impugned order, my lords. We are already coordinating, my lords, to procure the entire LCR, my lords.
This is not the way. See, after summer vacation, I will not grant any time to you.
My lords.
Well, if it is serial number 36, then I'm appearing on behalf of the appellant.
Serial number 40.
Oh.
What is 124A, Mr. Sharma? You come within the ambit of 124A.
May I be allowed to place, my lords?
Yes, Mr. Sharma, Vijay Sharma.
Lords, my learned senior is on mute, my lords.
Unmute yourself. Yes, Mr. Sharma, what is untoward incidents? What is the definition of untoward incidents?
May be allowed, Miloj.
May I audible, Lordship? 124, Your Lordship, compensation on account of the untoward incident, Your Lordship. When in course of the working in the railway, untoward incident occurs, then whether or not there any wrongful act or neglect or default on the part of the railway administration, Your Lordship. Such one would be entitled to a passenger who has been injured or dependents of the passenger who has been killed to maintain an action and recover damage in respect thereof. The railway administration shall not withstanding anything contained in any other law be liable to pay compensation to such extent to may be prescribed, and to that extent only to the loss occasioned by a death or injury to a passenger as a result of such untoward incident. And,
Yes, in the
and
facts
in
of
this
the
case,
case,
Your Lordship,
in the facts of this case,
this
whether
was
you are entitled for any compensation.
going to the natural corollary.
123C is the definition of untoward incidents. One 23.
123. See, Lordship. See, the commission of the terrorist act within the meaning of the subsection 3 of the Terrorist and Destructive Act, and making violent attack of commission of the robbery and indulging of the writing of sort of erosion by any person or any other train carrying passenger or waiting hall, clock room and reservation or booking office or any platform or any other place within the precincts of the railway stations.
Yes.
And Your Lordship, this is was this is as per the as per the case of the fact, Your Lordship, the victim had gone to the Dhanbad from the Katras by the passenger train, and he purchased the journey ticket of Katras because he was going back to the Dhanbad. He was waiting for train to Dhanbad, but the meanwhile, Your Lordship, the passenger train number so and so 88 5A and 6A of the Katras station died due to injury of sustained by the injury. It alleged the loss of the injury. And this case, Your Lordship, the disease was going to the natural corridor, and some train, Your Lordship, dashed to the
So this
Your
is
Lordship,
your
and
admitted
thereafter
case
he was the dead body was
that,
recovered, Your
that
Lordship,
to,
from the railway yard.
Mr. Sharma, this is your admitted case that to answer the call of the nature, he went towards the shed, towards the railway siding. Was he authorized to go towards the railway siding? Then tomorrow you will say, I will walk between the two tracks. And if some accident takes place, he will say that he would be entitled to receive compensation. Has this accident had taken place? You see, first of all, you have to establish whether this is an untoward incident or not, as defined under 123C. We have read 123C. Does it come within the purview of 123C? This incident?
123 C, Your Lordship.
123 subsection C defines untoward incidents.
123 C, Your Lordship.
Yes, read that.
Lordship. Uh, one Roman 1 the commission of the terrorist the commission of the terrorist act within the meaning of the subsection 1
It is
section
not
3 of the terrorist
this
and
is not applicable.
destructive activities
This
prevention
is not applicable.
by Act 1986. Lordship, the
This
make
is not applicable. Now
Lordship.
two. 2 is also not applicable. 3 is also not applicable. Then
2 and 3 also not applicable, but
123
you also
C
by any person in
yes
120 by any person in on any train carrying passenger or any waiting hall, clock room, reservation or booking office or any platform or any other place within precincts of the railway station or the accidental falling of any person from the train carrying a passenger.
your case is governed by which section?
But you also
Tell me, under which provision, under which section your case is covered?
but you also only for the case only in this ground lordship the dead body was recovered of the railway yard
Everybody was
lordship
covered in the
and
yard.
at
That
the
is the
time of
only ground. That will not
lordship.
come within the purview of section 123C or 124A.
It is it has not come under the purview of the 123.
Yes.
Kindly some time may be given lordship if in
No.
any
It's a
judgment
hearing
your
case.
lordship
Hearing case, there is no time.
support your lordship.
You have argued. You have argued. Sorry. Judgment reserved. There's nothing new in it.
Lodge, there's a particular, Lodge, if I may place a judgment, Lodge, with regards to untoward incidents versus self-inflicted, Lodge.
This is not self-inflicted. This cannot be also self-inflicted.
Like,
What is the judgment?
Lodge, AIR 2018 SC 2362, Lodge. It comprehensively details the Lodge, AIR 2018
Yes.
SC
Yes.
2362, Lodge. Lodge, I may be allowed to mail the copy of the judgment, Lodge. It comprehensively deals with the definition.
I'll get it from there.
Obliged, Lodge. Deals with the definition of untoward incident.
Yes. Judgment reserved. Possible. For the possible.
Possible matter, serial number 36, MN number 417 of 15.
Hello, I appear on behalf of the appellant. Our claims has been rejected. That is why we are here. The award starts from page 21.
21.
Yes, there are two contrary findings as observed by the court below. The observations and the issues have been dealt at page 24.
Read the award.
Yes, I'm reading from page 21. The applicant Srimati Sulekha Devi has stated that her husband Binay Paswan, while traveling by train from Gaya to Gomo on 12 to 2011, fell down between Bhulidi and Nimia Ghat stations at kilometer 30601 and died on the spot. He was traveling with a general ticket bearing number 71303-668, a photocopy of which has been annexed with the application. She has claimed compensation rupees 4 lakh with interest for herself and minor son Rabish Kumar. The respondent in the written reply has contested by stating that the journey ticket recovered from the body of the deceased shows that it was issued at 22:09 hours on 12/2/2011 from booking counter number 4 of Gomo station, whereas informant PW1 Parasnath asserts that the person's body was found much earlier at 10:30 hours on 12/2/2011, and he gave his statement before the OCGRP at 16:45 hours on the same day, which is six hours before the ticket was issued, which clearly shows that the claim of the applicant is false and maliciously distorted with ulterior motives. Hence, the deceased was not a bona fide passenger. The applicant has not proved that he fell down from the train, as there is no evidence of any eyewitness. That the claim should be dismissed. The DRM's report, based on the inquiry to be done under the Railways Passengers Manners of Investigation of Untoward Incident Rules 2003, has not been filed. On 19/2/2014, after hearing both the counsels on perusal of records, the following issues were framed: whether Binay Paswan was a bona fide passenger as alleged, whether there any untoward incident as defined under section 123C2 of the Railways Act 1989 occurred to him while traveling by Gaya passenger on 12/2/2011 from Gaya to Gomo, whether the applicant is entitled for the compensation as claimed by the or and any other relief if any. In support of her claim, the applicant has produced herself as witness AW1 and one Sri Sudama Paswan as AW2 and has furnished the original certified copies of the following documents which were marked exhibits as A. Report dated 13/4/11 of Court of District Magistrate Dhanbad. B. FIR as Exhibit 2. Final Report Exhibit 3. Fardbian of Sri Jayaprakash Rajmar Exhibit 4. Dead Body Chalans Sending for Postmortem Exhibit A5. Inquest Report Exhibit A6. Post-Mortem Report Exhibit A7 and photocopy of voter ID of Sudama Paswan Exhibit A8. On the other hand, the respondent has not adduced any witness, either oral or documentary evidences. Heard the arguments of both the sides, the learned counsel for the applicant pleaded that the applicant is entitled to compensation since the deceased had an accidental fall from the train due to rush of passengers as established by the police records. Further, he was a bona fide passenger as the certified copy of the ticket has been filed. He submitted the citation Honorable Patna High Court in Gauri Shankar Bind and others, another versus Union of India, 2014 1 TSA 820 Patna. The learned counsel of the respondent vehemently argued that as per the Fardbian of the informant who was the gangman, he was ordered by his superior, that is PW1, at 10:30 hours on 12/2/2011 to go to the site where he found the dead body of the deceased. However, the ticket which was recovered from the body of the deceased and filed by the applicant Exhibit A shows that it was issued on 22:09 hours, that is about 11 hours after the body was found. Hence, the ticket was not a valid ticket and the deceased was not a bona fide passenger. Moreover, he pointed out that though the inquest report does not show the recovery of the ticket, the final police report, Exhibit A3, makes a mention of the above said ticket, which creates serious doubt on the conduct of the police officer. He submitted the following two citations. Honorable High Court of Punjab and Haryana at Chandigarh in Ishwar Devi and another of India, Union of India 2005 ACJ 808 and Honorable Patna High Court in Maghu Sahu versus Union of India, miscellaneous appeal number 840 of 2011 in support of his argument. After perusing and examining the record, the decisions on the issues are taken up in Seraton. Issue number 1. The applicant submitted a photocopy of ticket number 713 dated 12/2/2011. It is seen from the photocopy of the ticket file that the ticket was issued at 22:09 hours on 12/2/2011 from Gaya booking counter, whereas as per Fardbian given by Ivan Sri Jayaprakash Rajbhar, gangman of Guliti station at 16:45 hours to Gomo, he has stated that 10:30 hours on 12/2/2011, as instructed by his senior, he had gone to the site and found the dead body of the victim lying between KM 306 3 and 1. It was on the basis of his above statement, UD case number 3 of /11 was registered. Thus, it is clearly established that the above said ticket was purchased in the night of 12/2/2011, while the dead body was found about 11 hours earlier on the same day. Thus, the ticket was not a valid ticket and the applicant had made out a false case in order to get compensation in this unfortunate incident. The respondent has submitted the citation of Ishwar Devi and another versus Union of India, the decision of which fully supports his argument. In this particular case, one Kanwar Bhan has purchased a ticket ex Patiala to Nabha, but the ticket allegedly recovered was found to be sold on the next day after the incident. Further, the inquest report, Exhibit A6, does not show the recovery of the above ticket. However, there is mention of the ticket in the final report, Exhibit A3. I am inclined to agree with the argument of the respondent that this makes the conduct of the police officer suspect and questionable and would rely on the judgment given in Maghu Saha versus State of Union of India, Supra, submitted by the respondent. The observations of the Honorable Lordship in paragraph 6 is given below. Non-mentioning of recovery of ticket in the inquest report was sufficient to come to the conclusion that the deceased was not having any railway ticket. Moreover, at subsequent stage, mentioning the ticket number creates serious doubt about the conduct of the police officer and on the case of the claimant. Thus, in view of the facts, I hold that Vinay Paswan, since deceased was not holding a valid ticket and he was not a bona fide passenger on 12/2/2011, the issue is decided against the applicant. Issue number 2. The applicant, along with one Sri Sudama Paswan, appeared as witness AW1 and AW2 respectively. Both during cross-examination stated that they had not seen the incident with their own eyes, and therefore their evidence could not be much used in deciding the case on this issue, as it is based on hearsay. The bench therefore examined the documentary evidence placed on the record, all the police reports, that is FIR, inquest report, final report, and SDM's order, speak in one word that the death was caused by falling down from the train. The respondent has not filed a DRM's report for which an adverse inference can be drawn. Further, no evidence can be adduced by the respondents to prove that the death was caused due to any of the exceptional clauses A to E of the provisions of section 124A of the Act, which would absolve the railways from payment of compensation. In absence of any credible rebuttal evidence, in my opinion, the fall from the train is accidental. Thus, based on the above facts, circumstances, evidences placed on record, I am inclined to hold that by the preponderance of possibilities, Sri Vinay Paswan, since deceased, had an accidental fall from the train and was a victim of an untoward incident as defined under section 123C2 of the Railways Amendment Act 1994. The issue is decided in favor of the applicant. Issue number 3, in view of the analysis and issue number above, the applicant is not entitled to compensation under section 124A of the Railways Amendment Act 1994. Well, now two contrary findings. I was not a bona fide passenger. That is, this is decided against me. Secondly, though I was a victim of an untoward accident. Now, Malad, as per the
Mr. Dev, how this is
yes.
How these two are contradictory facts?
Malad, I say this because Malad, the compensation, because as per the Railways Act, 124A, the compensation has to be extended to the person who are victim of the untoward accident. And if it is not extended, there are certain parameters which needs to be followed, which has been envisaged in the same section 124A. So, 120 section 124F is I'm allowed to read it again, Malad sir. Malad 124A of the Act of 1989. When in the course of working a railway an untoward incident occurs, then whether or not there has been any wrongful act, neglect or default on the part of the railway administration, such would entail a passenger who has been injured or the department of the passenger who has been killed to maintain an action and recover damage in respect thereof. The railway administration shall, notwithstanding anything contained in any other law, be liable to pay compensation to such extent as may be prescribed, and to that extent only of loss of occasion by the death or injury to a passenger as a result of such untoward incident, provided that no compensation shall be payable under this section by the railway administration if the passenger dies or suffer injury due to suicide or attempted suicide by him, self-inflicted injury, his own criminal act, and any act committed by him in state of intoxication or insanity. Any natural cause or disease or medical or surgical treatment unless such treatment becomes necessary due to the injury caused by the said untoward incident. And for the purpose of this section, passenger includes a railway servant, a person who has purchased a valid ticket for traveling by a train carrying passengers on any date or a valid platform ticket and becomes a victim of an untoward incident. Well, however, the definition of passenger has been defined in the other section, but this section 124A gives Malas two more additional grounds in terms of definition of passenger Malas. And the compensation has to be given in incidents when there has been any untoward incident. Subsequently, it can be when the person falls within this 1, 2, 3, 4, 5 categories. Malas. I do not fall within the five categories.
So Dev, is it your case that if a person doesn't have a valid ticket, but he falls from a train, admittedly he falls from a train, meets with an accident and dies, he is also entitled to receive compensation?
Malas, in view of the region of India versus Veena Devi, reported in 2019 volume 3 SEC, page 579.
Yes, 579.
Page paragraph 29. Not if I'm allowed to read only paragraph 29. Yes. It says that, however, mere absence of a ticket with such injured or deceased will not negate the claim that he was a bona fide passenger. Initial burden will be on the claimant, which can be discharged by filing an affidavit of the relevant facts, and burden will then shift on the railways, and the issue can be decided on the facts shown or attending circumstances. My initial burden was upon the claimant to prove that whether it was a bona fide passenger or not, madam.
So what?
Now they have.
How have you proved that he was a bona fide passenger? Initial
burden, however, the ticket.
Listen, Mr.
Yes, ma'am.
Initial burden was upon you.
Madam.
How you discharged that burden?
There was a production of ticket which was found on the body, which found mentioned in the final form. However, Malad, if I see, if the FIR is seen, this case, this number of ticket is also mentioned in the FIR. Malad, the FIR was lodged on the very same date at 1600 hours. Malad. It finds mention of that ticket.
The ticket number is mentioned in the FIR.
Malad, the ticket number is mentioned in the FIR. Malad. Malad, the ticket number is mentioned in the FIR.
What is the ticket number in the FIR?
Malad, it's written 71303-668.
The same which is there in the order.
Yes, Malad. 71303 668. Malad, it is mentioned at page 24, issue number 1, subparagraph 7.1.
Which page of the judgment it has been dealt with?
Malad, page 24, issue number 1, subparagraph 7.1.
In the judgment?
In the judgment, in the impugned judgment.
7.1.
That is page 24 to my memo, Malad.
Yes. What is the ticket number? Ticket number is not mentioned.
Malad, the applicant submitted a photocopy of ticket number 71303 on the very first line.
Okay, yes.
Photocopy of ticket 71303-668 dated 12/2/2011.
But that was issued much after the death of the deceased. How do you overcome this?
Malad, this ground which has been taken into consideration by the court below, whether the issuance of the ticket was on the date or it is much after this occurrence had happened. Malad, now, Malad, what I could understand, Malad, the initial burden would mean that I had come with the prima facie evidences on my part that he was a bona fide passenger having a ticket which was mentioned in the FIR.
No. You have the initial burden was upon you.
Malad.
You have come up with a plea that, look, this is my case. There you have discharged the burden, but they have reverted and they have demolished your plea.
Malad.
Then
that is why, Malad, the initial burden shall always be me, because under the Railways Act, it is the passengers who are only covered.
Your initial burden you have discharged, but they have demolished your initial burden.
Malad.
Now, is it your case? Is it your alternative case? Okay, forget about the ticket. Even if there is no ticket, I am entitled to receive the compensation. Is it your argument?
No, Malad, because this fact was taken into consideration, I had to, because on such findings, my case has been demolished. So I need to get over this, because that would be my alternative argument, because that is some arrangement which has been made by the judicial pronouncement that however it is the mere production of ticket is not necessary. In absence of ticket, the prima facie.
Here it is not a question of absence of ticket.
Malad, yes, Malad, that I understand, Malad.
Here you have produced a ticket and it has been held and they have proved that this ticket was not there.
Yes, Malad.
So if in absence of ticket means the pleading should be, yes, he was traveling with a ticket, but it got lost. Then the presumption.
No, that is not. That is not the case here, Malad.
Then the presumption would come that since a person was traveling, it will be deemed that he was traveling with a ticket. This deeming effect will come.
Malad.
So you do not bring yourself within the deeming effect. Once you have produced the ticket, that means there was a positive assertion on your part that yes, I was traveling with this ticket.
Malad.
And they have demolished your.
On the conduct, the another ground would, because there is one judgment which the lower court has relied upon on the conduct of the officer. Because now it is the case where it is not that any manipulations or subsequent changes have been induced by the claimants, but it is only the officer was.
Where is the ticket?
Yes, ma'am. Malad, on the conduct of the police officer on paragraph 7.2 of my at page 24.
No, I have seen that. Just tell me,
Malad.
where is the ticket? Ticket has been exhibited.
Yes, ma'am. The ticket has been exhibited.
It was issued on 12/2/2011 at 22:09 hours.
Malad.
FIR is dated.
Malad, the FIR is dated 12/2/2011 at 16:45 hours.
Where is the FIR?
The FIR was also exhibited.
Where is the FIR?
Malad, that would be exhibit A4.
A4. Where is it?
A4.
A4. I'm not getting the ticket. Just a minute. This is the UD case which you are referring to. Yes? Mr. Shamavesh? Mr. Samavesh? Mr. Samavesh? Yes, Mr. Samavesh. Mr. Samavesh, can you hear me? Can you hear me, Mr. Samavesh? Mr. Samavesh, you come to the impugned judgment. Can you hear me?
Malad, I can hear you now. Malad. There was some technical difficulty. Malad, now it's good.
Read para 7.1.
Yes, Malad. The applicant submitted a photocopy of the ticket number 713036668 dated 12/2/2011.
Just tell me, how could you get a photocopy of the ticket?
It is seen from the photocopy of the ticket filed at the ticket.
How just answer this question. How do you get a photocopy of the ticket?
The photocopy, it is only on the applicant that she had submitted a photocopy of the ticket during this case was as an exhibit, Malad. So
just a minute. The person died. It is your case, but the ticket is with that person. It was recovered by the GRP. The entire original ticket is with the GRP. The original ticket is with the GRP. How could you get a photocopy? It is your case that the GRP had given you the ticket. Because once you are purchasing a ticket, this general ticket, or is it your case that deceased has photocopied the ticket and send it to you and had sent it to you?
no, this was not the case. This is because
you come to the UD report. You come to the UD report. देखिए उसमें क्या लिखा हुआ है प्रथम इत्तला रिपोर्ट के क्रम संख्या देखें on the right hand side, on the left hand side, have you got it?
Yes, ma'am.
प्रथम इत्तला रिपोर्ट क्रम संख्या 3/11/12/2/11 and 13/2/2011 also mentioned.
Yes, Manoj.
Where is the ticket number in this? Where is the ticket number mentioned in this document? This document doesn't contain any ticket number.
Manoj, in exhibit, however, in exhibit A3, that is the UD report.
Yes.
Manoj, in the middle portion, it has been stated that मृतक के पास से रेलवे टिकट नंबर 71300668 जो गया जंक्शन से घुमो जंक्शन का दिनांक 12/2/2011 को जारी किया गया है. इस यूडी कांड में अब तक जांच घटना स्थल का निरीक्षण वादी गवाहों A3.
A3. Where is A3? What is this A3? Tell me.
That is the final report.
The final report
is the final report. So in the FIR it has not been mentioned. In the inquest report also it has not been mentioned. So
I see the FIR. I say that it is though it is mentioned, but however, it was one because once it is heard, it was also argued that it seems that it has been inserted in between.
Miloj, if I may be
the case, the number of ticket.
Where is it?
Page number 12, Miloj.
If it is
page number 12 of?
Page number 12 of the memo of appeal, Miloj. 1, 2, 4th line from the bottom, Miloj.
Page number 12.
Because the insertion becomes clear from one fact, Miloj, which is allowed to place, Miloj.
Yes, however, insertion and manipulation was not the ground for rejection, Maharaj. It was only the discovery of a ticket which was issued as a belated stage. It was taken into consideration. It is only our apprehension that it has been inserted.
Miloj, this if one small submission, Miloj.
Yes.
Miloj, this particular Fard Bayan, Miloj, at the top, Miloj, it is written, Miloj, that it was recorded at 16 and 45 hours. 16 hours 45 minutes, Miloj.
Yes.
The ticket itself, Miloj, was issued at 2209, Miloj.
Yes, I've seen that.
Miloj, how could this be recorded in the Fard Bayan when it was given at 1645, Miloj?
Yes.
Miloj, and the judgment, Miloj, of the Honorable Patna High Court, which has been relied upon by the learned court below, Miloj.
And this line, Mritak ke paas se, this line has definitely been inserted because you see the spacing of the other lines.
Indeed, Miloj.
मिस्टर भंजदेव, this
Malas.
line मृतक के पास से उसके बाद यही मेरा बयान है, यही हमारा बयान is overlapping this line. दोनों लाइन का बीच में इसको लगाएगा, इसीलिए यही मेरा बयान है कि ओवरलैप हो गया. कहीं भी रिटन में राइटिंग में ओवरलैपिंग नहीं है.
Malas, unfortunately, I'm not that kind of expert, Malas. But though this was taken into consideration, this point was, however, not taken into consideration by the court below. But then this ground, yes,
Come to the inquest report.
yes, Malas.
This was recovered from the body. What is annexure 1? What is annexure 1?
Malas, annexure 1 is the what is registration of the UD case, Malas.
Yes.
And it is registered on 12/2/2011 at समय 2 बजे.
समय
11:25 minutes.
No. 2 बजे.
समय 2 बजे.
What 25? 11:25.
Maloj, page number 11, Maloj, column number 4.
11:25.
Maloj.
11:20.
Badi, who is the Badi?
Wadi. Wadi is the Malas, the gang man.
So when this
Jayaprakash Rajwar.
So Jayaprakash Rajwar's statement was given on 11:20 at 11:25, Mr. Bhanjdev.
Malas. Yes, Malas.
Then how could his statement again be recorded at 16:45 as an FIR? He has already given the statement. He has already given his statement at 11:25, which was registered as UD case.
It was registered as an UD case, Malas.
So you come to page 11.
Yes, I'm on page 11.
It says Pardhyan of Jayaprakash Rajwar so and so at 16:45 hours.
At 16:45 hours.
But the Pardhyan was already recorded in 11:25 hours. So this doesn't create a doubt. Tell me.
Malas, however, this was the Malas 11:25. However, Malas, this body was found at 10:30 hours in the morning by this gang man.
Then
And in his FIR,
11:25 recorded.
no, Malas, 10:30, this person was asked by his superior officials about any body lying on the tracks.
Okay.
So he went there and subsequently, because I'm reading what I can infer from the FIR at page 12, Malas.
But one thing is sure, this ticket number has been inserted. And that too, the ticket that was purchased was much after the accident had taken place.
Malas, that time gap is there, Malas, but then, however, this was not brought in the record. This was not challenged in the court below. Because I do not see any.
I'm sitting in an appeal, Mr. Bhanjdev. You have to
Yes, Malas, that's why it was, because I do not see any reasoning, because I could have, Malas, I could have defended the reasoning which was given in the court below, Malas. Now this could be entirely a fresh ground if I urge it before, Malas.
No, this is not a fresh ground.
Things would have been definitely easy, Malas, if there was no production of ticket at least. Well, now only on production of this ticket, Malas, the things have become complicated. That is because the reasoning even recorded by the code below, Malas, the mode by which the issuance of this ticket or this genuinity of the ticket, it has been determined by the code below on just after having a glance of it. It is just said that it has been issued on at a time which is much after the cause of death.
Absolutely. Absolutely. You have produced it. And the ticket shows that when at the time of purchase, when it was issued. The ticket, you have the ticket with you? See?
Well, the those that should not be annexed by us in the next. But then again, it was exhibited.
12 to 2011, 2209.
Yes, Manoj.
Then only now let us read again this provision of law.
Hello.
Let us read the other way around.
Hello.
Explanation says, for the purpose of this section, passenger includes. That means it's an inclusion clause. The word passenger will include who? A railway servant on duty, a person who has purchased a valid ticket for traveling. That means a person who has purchased a valid ticket for traveling by a train carrying passengers on
for traveling,
or a valid platform ticket and comes a victim of an untoward incident.
Untoward.
That means it doesn't say that a person who has fallen from a train must have a valid ticket.
Manoj.
Now, if you see 123 C2, it says an accidental falling of any
C2.
passenger from a train carrying passengers. So, what does this word see? What does this line? For the purpose of this section, passenger includes. What does definition inclusive clause means? Tell me.
Malas, now perusal of these two clauses, Malas, it still gives me a hope that mere production of a ticket would not make him a passenger.
It's not that easy. What does this word includes mean?
Well, I guess include would be specifically dealt only in the incident of untoward incident. For in any incident of untoward incidents, there has been given a broader, a few more lines have been added to bring it within the ambit of definition passenger.
I'm asking you a simple question. When there is a definition in a law, the so and so means and includes. What is the interpretation of law?
It shall mean that.
Have you gone through the book Interpretation of Law? Have you read?
Not anytime soon, Malaj.
Then how can you answer this question which I am putting?
Yes, Malaj. So, Malaj, that cannot be answered abruptly and without application of yes.
What does the word in a definition, if it is there in a definition clause, includes? What does it mean? Show me with authority what you are saying.
Malaj, I'll have to go. So, Malaj, let me
come at 1:30. Come at 2:50. Come at 2:50.
2:50, Malaj.
Yes, the word includes means in the definition clause.
Bali.